Welcome to the White Knight Theater. I think almost no one can climb over this windbreak fence covered with thick vegetation without damaging any of it. Hitting the air conditioner and losing the glove should be someone unfamiliar with Rockingham. Therefore, we oppose the defense's claim and believe that the evidence found by Furman and others should be submitted in the United States. The defense and prosecution are two completely equal opposing teams. The courtroom is similar to a sports field, where the fairness of both sides comes from the referee, that is, the judge's maintenance of the rules of the game. So, what will be the conclusion of Furman's entry into Simpson's home in the preliminary hearing? Will the judge blow the whistle on the prosecution like a referee? Produced by Himalaya, the 14th episode of the Chinese-American detective Dr. Lee Chong-Yu's crime drama, The Dream Team's Grand Deliberation. In an office of the prosecution, Dr. Lee Chong-Yu and Sam are continuing to review the key Detective Furman's personal account of why he climbed over the wall. Note that this account is difficult to verify because it involves the issue of motive. So, how will Dr. Lee determine the credibility of this account? Why didn't you first secure the scene and then enter O.J. Simpson's private residence after obtaining a search warrant? Rockingham. At that time, in such an emergency situation, we didn't have time to stand on the street and wait. What emergency situation? Of course, it was possible that someone was injured. Stop. I'm worried that someone is hurt. Dr. Lee, whether it was Furman or Warner, they both said that they entered Rockingham without a search warrant because they were worried that someone was injured. But in fact, it was not the case. Dr. Liu, what do you mean by that? Although we knew afterwards that no one was injured, they didn't know at the time. We can never rely on anyone's words to draw conclusions. We need to find answers by analyzing their behavior. First of all, in their action records, they talked about how they found the bloodstains on the white Mustang, how they entered Rockingham, and how they met Lieutenant Cato and O.J.'s daughter. But what is missing? Missing the search for injured people. Exactly. They all said they were worried that someone was injured. But in their records after entering Rockingham, there was no behavior of searching for injured people. But is there a possibility that they searched but did not record these actions? The possibility you mentioned does exist. That is, they did not record carefully and there were oversights in their work. Only this time, the possibility is very low, because in the testimonies of Lieutenant Cato and O.J.'s daughter Arnell, both clearly stated that Furman and others did not search for injured people. They only asked where O.J. was. You think Furman and others may have already violated the presumption of innocence, and in their minds, they had already determined that O.J. was the murderer without confirmation. Don't talk now, someone is coming. Shapiro said, the materials the gentleman wanted were ready. Dr. Lee Chong-Yu had arrived. Ready, I'll take them over. Dr. Lee Chong-Yu was already in the office. Dr. Lee, you're here. Yeah. Are the others here yet? Robert Shapiro was very excited about Dr. Lee Chong-Yu's discovery and immediately organized an internal defense team meeting. I think Dr. Lee's discovery is very valuable. It was also at this meeting that the Dean of the School of Law at Santa Clara University, Gerald F. Ullman, proposed a very bold motion. This motion is based on the exclusionary rule in the Fourth Amendment to the U.S. Constitution. In this way, Furman and others' entry into Rockingham was illegal, and we can reasonably believe that the evidence they obtained in Rockingham was also illegally obtained. According to the exclusionary rule of the Fourth Amendment, we can ask the judge to exclude all the evidence collected in Rockingham on the grounds that illegally obtained evidence cannot be used against the defendant in court. The Fourth Amendment clearly stipulates that the court must exclude evidence obtained by the police through illegal searches during the trial. According to this regulation, if the police want to enter a private residence for a search, they must swear to the judge. Not only must they list the evidence and reasons in writing, but they must also specify the location, scope, and time of the search. Only after the judge's approval can they enter the private residence for a search. Only after the judge's approval can they enter the private residence for a search. In addition, the police can only act within the specified scope and must submit a report of the obtained evidence to the court after the search. If the police conduct an illegal search, they will not only be severely punished but also face the serious consequence that the obtained evidence will be invalidated in court. This is very consistent with the poisonous tree theory I once taught in our law school classroom. When a poisonous apple appears on an apple tree, we can infer from a certain angle that the other apples may also be poisonous. Whether they're actually poisonous or not, the apples on the whole tree can no longer be eaten. Once our strategy succeeds, I believe it will be another successful teaching case. Ha! Lawyer Ullman is indeed a teacher at our law school. This metaphor is very vivid, and I think this idea is fine. Dr. Lee, what do you think? From information I have obtained so far, many of the prosecution's evidence are worth investigating. I suggest everyone wait a little longer and give me more time to clarify the evidence part. To be honest, I don't want to see the police rush into the issue of OJ, but I also don't want to see the defense do the same thing. We haven't done anything wrong. This is the law written in black and white in the Fourth Amendment. Yeah, we have one more thing. The Fourth Amendment also points out that there is a situation where the government will be recognized even without a search warrant. According to the description of the regulations, that is, unless the evidence would still be inevitably discovered under legal means. That is to say, we also need to consider the rationality of the discovery of the evidence. If the prosecution gives this answer to your exclusionary rule, it will be very difficult to proceed. In the investigation of major murder cases around the world, there is a saying circulating within the police. When a woman is killed, the first person to suspect is the husband. After divorce, when a woman is killed, the ex-husband is the number one suspect. Did Furman violate the presumption of innocence for this reason and forcibly entered Simpson's mansion? And did he place the bloody glove here quietly to give an account for this illegal act? The defense team discussed this issue fiercely, but they ignored a core issue. So what you are discussing now is that Furman placed the glove to reasonably enter Luo Jean. But there is a biggest problem, that is, the glove must be found somewhere by Furman. Is the blood on the glove really from the heart? And the biggest problem that has never been seriously mentioned is the physical evidence of the murder weapon. The most important factors of the murder case are the motive, the time of the crime, and the murder weapon. Where is this physical evidence? Will it appear? It is more important to answer these questions. After this meeting, Dr. Lee Chang-yu flew to Seattle to attend the annual meeting of the American Academy of Forensic Sciences. The preliminary hearing began during this trip. The presiding judge was named Lance Ito, around 50 years old and of Japanese descent. Amidst the severe racial tensions in this case, his Asian identity would shield him from media attacks and allow him to remain as impartial as possible. At the outset, facing the prosecution's confident charges, Attorney Ullman calmly proposed, in accordance with the exclusionary rule of the Fourth Amendment, to request the court to exclude the evidence obtained in Rockingham and dismiss the case. However, this proposal was strongly opposed by the prosecution, Ms. Marcia. Your Honor, I oppose. I believe Attorney Ullman's reasoning and interpretation of the Fourth Amendment are overly simplistic and one-sided. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures is indeed enshrined in the Constitution, as Ullman correctly pointed out. However, it seems to overlook some issues, whether intentionally or due to professional inadequacy. After the 1960s, with the sharp rise in crime rates, the strict implementation of the exclusionary rule, as advocated by Ullman, became overly lenient towards criminals and cruel to the public, allowing many criminals to go free despite overwhelming evidence against them. Therefore, in 1984, the Supreme Court ruled that when a search does not fully comply with procedural requirements, if the police act in good faith and reasonably, the court may still admit the evidence obtained during the search. In the Simpson case, Furman and others had no issues in their previous work, thus establishing good faith. Given the bloodstains at the door and the prolonged absence of response when knocking, Furman and others had reasonable grounds to enter Rockingham. Therefore, we oppose the defense's motion. We believe the evidence found by Furman and others should be admitted. For over 3 hours, the prosecution and defense fiercely debated whether the evidence obtained by Furman and others in O.J. Simpson's private residence, Rockingham, could be legally submitted, with no conclusion reached. In fact, the laws and regulations regarding searches are extremely complex and lack clear, explicit provisions. For example, It is illegal for the police to stop and search civilians without cause. However, if someone is speeding, the police have the right to stop the driver and issue a ticket. But if the police take the opportunity to conduct a body search and search the car, the driver has the right to refuse on the spot. However, if the police inadvertently find something resembling a marijuana cigarette on the back seat of the car without a search warrant, do the police have the right to search the car? If the police search the entire car and do not find drugs, but unexpectedly find an illegally possessed firearm, is the police's car search action unconstitutional? And can the illegally obtained firearm be used as evidence in court?